All right, we're running a little behind, folks. This, for the record, this is the James Ferguson case, 10 CRB 653, and that's 1 of 2 and 2 of 2, 2 falsification charges. Mr. Ferguson had previously pled no contest, and court had ordered a pre-sentence investigation, which it has had an opportunity to review, and also a sentencing brief filed by the special prosecutor in the case. And Mr. Morehart, the only thing I was going to ask you right now is, in your memorandum, you make reference to a transcript, and it says it was attached, but it didn't appear to be attached.
My apologies, Your Honor. I believe that.
Do you have a copy of that?
I'll find that for you.
Okay, thank you.
And I would like to present one witness.
That's fine. The witness is Mr. Oswalt.
Yes, sir.
You want to come forward?
Certainly. Response. Do you solemnly swear the testimony you're about to give the case now being heard, so the truth, the whole truth, and nothing but the truth, so help you God? I do. Please proceed, sir. Sir, would you state your full name and spell your last name, please?
Kenneth W. Oswalt, O-S-W-A-L-T,
State your complete business address.
Lincoln County Prosecuting Attorney's Office, 20 South 2nd Street, Fort Flora, Newark, Ohio.
Thank you.
You may proceed, sir.
Mr. Oswald, are you familiar with the state case of State of Ohio versus Virginia Lefevre?
Yes, I am.
Please tell the court how you're familiar with that.
Time it was tried in 1990, I was co-counsel with former prosecutor Bob Becker.
And are you in fact familiar with the chief forensic toxicologist who testified for you in that case?
I am.
Who was that?
James Ferguson.
That person you know is James Ferguson, present today?
He is. He's sitting right there.
Okay, now you understand that Mr. Ferguson has pled no contest to 2 counts of falsification, and you also understand how that occurred. Please tell the court what your recollection of that is.
Yeah.
Start wherever you would like as to the significance of that.
I obviously was made aware that Mr. Ferguson entered no contest pleas to the charges that you had filed. Obviously, my interest in the case has to do with the fact I'm still deciding what I'm going to do with the underlying conviction on Virginia Lefevre. Obviously, some of the decisions to be made in the future would be potentially made by Judge Weiss, the assigned judge. The parties in that case, that is Mrs. Lefevre's counsel, myself, are currently working on acquiring other information so we can have the court make the most appropriate decision. But the very fact of the matter is that it pains me to even have to be in this posture. Mr. Ferguson, I considered to be a friend. I don't know what he feels now, but as a public prosecutor, a government witness in any case testifying falsely for whatever their motivations is just not something we can countenance. The Jim Ferguson I know, and that may be the same Jim Ferguson here today, would acknowledge that. And maybe yet today he will acknowledge that. He obviously did that in some sense by his no contest plea, but just so the judge understands the consequences is that if Mrs. Lefevre's conviction is set aside, she potentially the state runs the potential of her getting 20 years of wrongful imprisonment money. A woman that may be perceived by some in prison wrongly for 20 years. I'm not one of those people, by the way. Regardless of what Mr. Ferguson did, I firmly believe Mrs. Lefevre is guilty. But at some point, having people found guilty, while that's important, getting there appropriately is just as important. And that's why we can't get there without consequences for those people that choose to misstate, lie, give false information. I wish I wouldn't have to be here. I wish I wouldn't have to make some decisions in the next coming months as to what's going to happen with Mrs. Lefevre, but I do.
So that we understand correctly, in 1990, this homicide trial took place?
February of 1990.
The gist of the allegations, without leading you too much, are that Mr. Ferguson stated he had a degree in biochemistry from the Ohio State University, granted to him in 1972.
In the testimony in 1990, he testified at least twice that his degree in biochemistry was granted to him by the Ohio State University in 1972. He repeated that claim in a deposition testimony in April of 2008, just over 2 years ago.
You were personally present in that deposition,
I was?
and so you had a first-hand opportunity to hear that.
I did.
And Mr. Ferguson had been sworn before his deposition was taken.
He was.
When did he eventually get his degree in biochemistry?
Records available from OSU indicated he finally was granted that in 1988, 16 years after he testified he'd actually gotten it.
But prior to the testimony in the Lefevre case? In other words, he had the degree when he testified as an expert in the Lefevre case.
Correct, because he testified in 1990.
So that we're clear about this, do you have any evidence that suggests that his conclusions that he testified to a reasonable degree of scientific certainty in that criminal case and subsequently were his forensic conclusions? Do you have any evidence that those were false?
I have, the defense has presented expert testimony in one proceeding and another that they think suggests that Mr. Ferguson's conclusions are false. I have not arrived at that conclusion myself, no.
As far as you could tell, the testimony he gave at the trial, other than when he obtained his degree, would have been truthful, but at this point, we can't be sure.
As far as I know, correct, right now, his expert testimony in terms of his opinions as to Mr. Lefevre's cause of death are accurate, although they are subject to disagreement by other claimed experts.
Is it clear to you that he obtained his degree in 1988?
It is clear that he obtained a degree in 1988, yes, according to what OSU records show.
Now, you subsequently had an occasion to converse with Mr. Ferguson, which is the principal reason why I'm here instead of someone else, about this matter of the degree in 1972 versus 1988.
That's correct.
Tell the court about that, please.
When I received a copy of the motion Mrs. Lefevre filed, or her attorneys filed on her behalf regarding wanting a new trial in February of 2009, I called Mr. Ferguson at his home. I actually at that point assumed that there was a record-keeping error and the claim about Mr. Ferguson's credentials was an inaccurate allegation. So I actually asked Mr. Ferguson, told him about it, and asked him about it, and there was a short period of silence that kind of told me that there was some truth to it. That silence was followed up with Mr. Ferguson confirming to me that, in fact, the allegation of him having lied was true, that he did not get his degree in 72, he got it in 1988, and I went one step further and asked why, to which he responded something along the lines of that he was in line to get his degree in 72, and I don't know if he was being figurative in that or literal, because he then followed up so he was actually pulled out of line, told he was missing some class or classes. I don't remember exactly what class, if he said at all what it was, but it struck me as somewhat inconsequential class. I don't know where class is. And when asked, well, why didn't you go back and do those classes until 88? And he said, work, family, those kinds of things, put that off until 88. And that was some of my conversation, because quite frankly, I was none too happy about what I was hearing.
Why is Mr. Ferguson's testimony, both in 1990 and in the deposition, what significance does that have to this homicide? Was it important evidence? Was it somewhat important?
Well,
What's your opinion?
the homicide case, in case people don't remember, it was an allegation that Virginia Lefevre poisoned her husband, William Lefevre. Result, toxicology was obviously an important part of that case. Was it the whole part of the case? No, but it was certainly an important part of the case. There was, depending on how you characterize it, 4 or 5 different poisons or drugs. There was an antidepressant, there was arsenic, 2 forms of strychnine, and some sulfur oxide fumigant sticks. So toxicology was a very integral part of the testimony in that case.
Was there competing scientific expert testimony with regard to toxicology, or was Mr. Ferguson's the only testimony?
Mr. Ferguson was the only toxicologist offered by the state. The defense had put on a purported expert by the name of Cavestri. I don't remember his full credentials.
There was some other scientific evidence presented.
Obviously, the county coroner, Dr. Raker, the pathologist, which would be the Franklin County deputy pathologist at that time, Pat Fardell, testified. In terms of expert testimony and the like, we had 1 or more doctors that treated Mr. Lefevre before he died in the hospital, and or some nurses. But in terms of true toxicology testing, I believe Mr. Ferguson was the only person that actually did hands-on testing. That testified. I believe Mr. Ferguson had some laboratory techs that would have assisted in some aspects of it.
As a consequence of all of this, you are now engaged in defending a motion for a new trial in the original homicide case?
I suppose technically that's yes, but I would like to clarify that. I'm trying to decide whether I should defend it.
Has something been filed?
The motion, obviously, for a new trial has been filed. I have filed a response that is asserting certain defenses to the claims, but at the same time acknowledging, conceding as I must, the false statement made by Mr. Ferguson. And there are certain, as in most motions filed 20 years after a conviction, there are a lot of legal arguments that lend themselves to be made about delayed discovery and the like, and those have been asserted. There's no set date by which the judge is ruling on. As I alluded to earlier, Mrs. Lefevre's attorneys and myself are coordinating to get some additional information, which is really can't be commented on because the judge sealed the entries related to that.
So you're still deciding what to do with respect to this particular issue?
That's correct.
I don't believe I have anything else, Your Honor.
Did you find that transcript
Your
that you
Honor,
were
I
going to?
apologize. I have not found that transcript. I have seen it, but I don't know where it's at right now.
Well, Mr. Oswalt, is the reason this wasn't treated as a felony offense because it wasn't a material falsehood or because statute of limitations had passed?
I'm not sure I can answer that completely, but I'll do the best I can. Statute of limitations for anything related to Mr. Ferguson's testimony in February of 1990 has long since passed. Well, that's misdemeanor or felony regardless. The only statute of limitations then would have begun to run April 2008 when he testified, repeated that falsehood in the depositions. Of course, I don't know anything about that until 2009 when the motion's filed, so there's a year gone, almost a year, before I even get wind of it. For the next year or so, in consultation with the presiding judge on the case, Judge Wiest, some discussions with Mrs. Lefever's attorney, we were trying to figure out where the motion was going to go. And the reason I, as a prosecutor, thought that might be important is until we know what the judge in that case does or what happens, therefore, to Mrs. Lefever's conviction, I could see any prosecutor wondering, is this material, is this not? The concern I then came up to in early April or maybe even late March was that if a prosecutor, because I already decided I wasn't going to make the call. I didn't think, because I had talked to Mr. Ferguson, I was so connected to the case, I wasn't going to be the person to make the decision on what charge to file. But I realized April 8th, 2010 would have been a 2-year statute of limitations on a falsification, which is what we're here today. So I decided, it looks to me like the decision on Mrs. Lefever's case isn't going to be made by then. I need to pass this off to a special prosecutor. So if that prosecutor chose to file misdemeanors or thought the fact pattern deserved misdemeanors over felony, he or she could do so. And Mr. Morehart made that decision. He had authority to do either of the two he wished. He is appointed as a special assistant Licking County prosecutor as well as a special assistant law director. So
Thanks for clarifying that. Anything else?
No, Your Honor.
Let me step down, sir.
Your Honor, I believe Mr. Goddardam is present, and I have the pleasure of the court whether you wish to hear from him or not.
Who's that?
He is Virginia Lefever's attorney.
I don't really, I don't want to treat this as a habeas corpus hearing. I don't have that jurisdiction. This is simply a falsification sentencing. Mr. Ferguson, would you like to say anything before the court imposes sentence? The court will find you, well, before we get to that, counsel, I think you have already said it, but would you state just for the record the factual basis upon which you are asserting that Mr. Ferguson is guilty of these two offenses?
Certainly, Your Honor. It appears to me that in a deposition, and I believe that was conducted April 8th of 2008, he made the statement several times that he had obtained a degree in biochemistry from The Ohio State University, and I believe the date was 1972. Subsequently, he's admitted to Mr. Oswalt, and by virtue of a contest plea to this court, he did not obtain that degree until 1988. So for the trier of fact in the homicide case and for the trier of fact in the deposition was in a rather esoteric proceeding to change cause of death in a death certificate in the common pleas court. That's where the actual deposition case was made. So for either of those cases, he made a clearly false statement to the trier of fact.
Are these allied offenses of similar importance?
They certainly are, Your Honor.
All right. Mr. Ferguson, do you care to make a statement, sir? The court will enter guilty findings on both of them. I'm only going to sentence you on one because these offenses are allied offenses of similar import. Go ahead, sir. You don't have to stand.
When asked what year I graduated, I indeed did state 1972 instead of 1988. With regard to my expertise, I had 20 years of education, training, and experience before the testimony in year 1990. And I continued for another 20 years until I retired. As to the charge, I did misrepresent the year that I graduated.
Anything else?
No.
Mr. Ferguson, the court conducted a pre-sentence investigation, which was, I think, pretty thorough. And one of the things that my probation department brought to my attention is that you're suffering from a fatal disease.
Yes.
What is your prognosis with that?
Well, I would hope for remission, but I'm more likely to die sooner rather than later.
What is your regimen for visiting the hospital and doctor's offices?
At the present time, I'm undergoing chemotherapy. This is a 6-month course. I'm midway through. So I received chemotherapy for approximately 3 days treatment, and then 28 days lapse before I receive treatment again.
Well, Mr. Ferguson, I guess I just have to say that I get the impression that you think that what you said was simply a misstatement and doesn't really amount to much, when in reality, may have meant a lot to the prosecutor, and it may have meant a lot to Mrs. Lefevre. Not here to discuss that case on the merits. Obviously, I don't have any jurisdiction, and frankly, I don't know much about the case, it having happened so long ago. But essentially, through your misstatement, through your lie, you deprived two parties of justice. And if you can't see where misrepresenting the date of your graduation from The Ohio State University is a lie and not simply a mistake or a misstatement, then there's nothing I can do for you. You implied that you had a bachelor's degree in the applied sciences and had it for 10 years when that trial took place. And that, I think, is probably a material fact. But anyway, and the other thing that upsets me about this case is people that take that witness stand lie all the time, but we simply don't expect it from public servants and officers of the court. The court, as I indicated, will sentence you on only one of these two charges. Will enter a fine of $1,000 in court costs, enter a jail sentence of 180 days. I'll suspend 150 days of that jail sentence, leaving 30 days to do. You'll be on probation for a period of 1 year following your release from jail. I will cooperate with the jail to make sure that you're not deprived of any of your treatments for your medical condition. Is there anyone in your family that has access to that information that they could provide the court?
Yes.
All right. We will also, because of that situation, give you a report date rather than having you incarcerated today. Court will stand in recess.
Thank you, Your Honor.